Welcome to the fourth session on the topic of international responsibility of states, where I explore the concept of the injured state and remedies. Please allow me another reminder that we are overviewing the legal regime governing responsibility of states in general international law, but other regimes might be regulated by treaty. The Articles on Responsibility of States actually remind us that more specific regulations might prevail in its Article 55. As we have seen, international responsibility is the legal regime regulating the legal consequences emanating from a breach of international law. Then, we have analyzed in some detail what conditions must be met to trigger international responsibility. That is, the existence of a breach of international law, what the International Law Commission Articles on International Responsibility called the Internationally Wrongful Act. Second, we have looked at the fact that the act must be attributed to a state, the topic of attribution. And third, we have seen that to raise international responsibility, we need the absence of conditions precluding wrongfulness. In this session, I outline the issue of legal consequences deriving from international responsibility. That is, what are the rights of the injured state and the obligations for the wrongdoer. The Articles on Responsibility of States for Internationally Wrongful Acts provide that the injured state, by the breach of an international rule, must notify the wrongdoer as a condition to invoke international responsibility. This activates its rights as an injured state. From there, states have a range of options on how to claim and enforce their rights. These are topics that I will address in specific sessions concerning mechanisms for the settlement of international disputes and enforcement of international law. I just want to point out here that in the context of the explanations on circumstances precluding wrongfulness, we have seen countermeasures, which is one of the means states may resort to in order to enforce a responsibility claim. Here, I am going to limit the explanations to the concept of the injured state, because only the injured state can invoke and claim international responsibility from the wrongdoer. As we have seen, the regime established by the Articles on International Responsibility codifying customary law rely on the idea that a harm derives from the mere breach of a rule of international law. Therefore, the injured state is the state towards which the obligation is owed. This is relatively clear when the rule breached is a synalagmatic treaty, that is, a treaty or other source of law that establishes reciprocal obligations. For instance, a treaty of provision of gas by one country to another in exchange of money. Or in my fictional example of the previous video, the agreement by which Sri Lanka allows India to exploit part of its continental shelf and in exchange it can fish in Indian waters. If one of the parties does not fulfill its obligations, it is very clear who the injured state is and who can invoke responsibility. However, some obligations are owed to multiple states or are set up in the context of treaties where the obligations are interdependent and the failure of a state to comply will affect the other state parties. Jorge Viñuelas, in its UN mini-series on international responsibility, uses the example of treaties on disarmament or environmental protection as examples where the existence of a free rider, a state that fails to fulfill its obligations, is likely to result in the condition of injured state for all the other state parties in that treaty. Article 48, reproduced here, assimilates to the injured state all the states of the international community when the rule breached is owed towards the international community as a whole, what we have called the erga omnes obligations. I refer once again to the International Court of Justice case law I listed in the first video I recorded on the topic of international responsibility. In addition, an obligation may be owed to a specific group of states if it protects a collective interest affecting that group of states. any state within the group will be assimilated to an injured state for the purposes of invoking responsibility. However, it is not clear what measures can a state that is not directly suffering the harm claim specifically apart from demanding the cessation of the wrongful act and assurance of non-repetition. Professor Shevas is explaining in another video the case of the Gambia versus Myanmar, currently pending before the International Court of Justice, and where he is acting as the lawyer of Myanmar. In this case, the Gambia is not directly affected by the alleged violations of international law committed by Myanmar. In particular, the Gambia claims Myanmar is responsible of the crime of genocide as defined by the Genocide Convention and customary law. No national from Gambia has suffered from the alleged genocide, and the violations claimed did not happen in the territory of the Gambia. The Gambia has claimed both the basis articulated by Article 48 and as I said, reproduced here in this presentation, to justify its standing as a state with the right to invoke responsibility. So first, the Gambia claims that the prohibition of genocide constitutes an erga omnes obligation owed to the international community as a whole, as a matter of international customary law. Also, therefore, all the states of the international community can invoke responsibility for genocide, whether or not they are parties of the Genocide Convention. In addition, it claims that erga omnes obligations are owed by any state party to the Genocide Convention to all other states party to that treaty. In its order on provisional measures, the International Court of Justice held that all member states of the Genocide Convention have a common interest to ensure compliance with the Convention that is derived from the shared values protected by that treaty. This order, and probably the final judgment on this case, will add an important judicial contribution to former case law of the court on this topic, particularly the Whaling case and the Belgium versus Senegal case. So let's move on now to the obligations that are borne for the wrongdoer. The first obligation is to cease the breach of international law if that is still ongoing. States should also provide guarantees of non-repetition. This is enshrined in Article 30 of the International Law Commission on Articles on International Responsibility of States for Internationally Wrongful Acts. The responsible state also has to provide reparations to the injured state. There are three main forms of reparations codified by the Articles on State Responsibility. First, when possible, a state responsible for an international wrongful act must try to re-establish the situation that existed before the breach of the international law existed. So this can be more or less easy if, for instance, we are in a situation of occupation by military forces. The state can just withdraw its troops and repair whatever damage was done by them. Or if it is a case of seizing property, the state can give back the property, or if it was a case where prisoners are involved, the prisoners can be released. When restitution is not possible, the wrongdoer must compensate for the damage caused. This involves a monetary compensation. Finally, a reparation can consist on a declaration that satisfies the injured state. For instance, acknowledging the wrongdoing or apologizing. When the misconduct of specific officials of the responsible state is involved, satisfaction can also consist in the punishment of those officials. So, for example, in the Rainbow Warrior case outlined in our former session, one of the means France agreed to repair for the damage caused to New Zealand was expatriating the agents involved in the attack to the Greenpeace ship. In addition, France also offered public apologies. Similarly, in a case between Costa Rica and Nicaragua that addressed the alleged occupation by Nicaragua of a territory belonging to Costa Rica, the International Court of Justice concluded that the declaration by the court that Nicaragua breached the territorial sovereignty of Costa Rica provided adequate satisfaction for the non-material injury suffered on this account. The pulp mills case between Argentina and Uruguay is another leading case of the International Court of Justice covering the different forms of reparation in international law. To conclude, Article 41 establishes additional obligations that are borne to every state of the international community when there is a serious breach of a peremptory norm of international law. These obligations are borne not only for the wrongdoer but for every other state, and involves a duty to cooperate to bring the situation to an end, the obligation of not recognizing the situation created by the wrongful act, as well as the obligation of not providing assistance in maintaining such illegal situation.